as a matter of law, there are no permits. And, of course, a permit does not create a water right. Only this court can create a water right. Okay, so the OSC, the non-existent fictitious permits do not create a water right. And then finally they say, oh, but the 1962 Act does. And we'll get into that when we get back to prong 4. And I hope you've had a chance to read our response on that claim. Because if you look at the 1962 NIP Act, which is 76 Statute 96, Section 13C of that Act says, quote, no right or claim of right to the use of the waters of the Colorado River system shall be aided or prejudiced by this Act. Close quote. There is an express congressional declaration that this Act does not create water rights. And why they never cited that to this court over all these years, I do not know. But the very plain text, and we'll provide the court a copy, no right or claim of right to the use of the waters of the Colorado River system shall be aided or prejudiced by that act, this Act. That means two things. One, Congress didn't create a water right for NIP or for the Navajos. And two, it didn't prejudice my clients who have existing adjudicated water rights. And it didn't prejudice all the other people who would like to have water rights in this valley. Now, so good question here, like what was Congress doing? You know, I mean, they passed this thing and they referred to diversion amounts. The answer is they were passing a construction project. It's a pork barrel bill. It says we're going to authorize the future expenditure of money to build canals and pumps and so on and so forth. And they're entitled to do that. But that creating the construction of waterworks doesn't create water rights. We all know that. What they were doing, Your Honor, and let me jump ahead, because all of this actually, the law as laid down by Congress and the courts is really quite coherent. What they were really doing is saying that the United States and the Navajos would acquire water the same way as anybody else under New Mexico law. Appropriate the water and put it to beneficial use. Now, that is in the New Mexico, U.S. versus New Mexico case, where they're talking about Federal Reserve rights. Can you find it out? Which one is that? I want to read the... They're talking about what inference are you going to draw from congressional action? Are you going to infer that they really did actually intend to reserve water for this particular reservation under those facts? And under the Winters case, when you go through it, it's absolutely clear. They did. They started working on waterworks right away, and by the time they got halfway finished, the water had been diverted upstream. So that's one inference. But it's, remember this, it's only a judicial inference about what Congress really intended. And that's a fact-specific inquiry. Now, in U.S. versus New Mexico, and I've got the citation here, and I can't quote it exactly, it says, there arises the contrary inference, that Congress intended that the United States would acquire water in the same manner as any other public or private appropriator. And that's what they did here. We're going to build this, and we're going to acquire water by doing what other people have done. That is, taking it from the river and putting it to beneficial use. The problem is, of course, NIP, I'm only talking about NIP, is not a beneficial use. They've conceded that on summary judgment. Anyway, let me jump forward then. That's the essence of our case. As I say, the law is actually coherent if you go back and read it through the ages and see what Congress was actually doing. Starting in 1902, water is cheap. You can't waste it. The admission of New Mexico to the Union, which expressly approved as the law in New Mexico, both prior appropriation and beneficial use. And New Mexico is the only arid state that was submitted to the Union after winters in 1909. It has an express prior appropriation clause in the Constitution. Priority of appropriation shall give the better right. That did not appear in the Arizona Constitution. So, if we do what lawyers almost never do, which is read the statutes, read them carefully to see what Congress wrote, it's absolutely coherent. Now, let me jump ahead. And we'll talk about this more tomorrow. So then you get to the question, the central question, which is, so, what are they legally and factually entitled to? Now, Mr. Pollock stood up and said, the Navajo Nation already possessed substantial water rights in excess of the amounts in this settlement. Whoa, wait a minute. Wow, wait a minute. That's begging the question. The question we're asking, how did you get the water rights? Winters? Something else? No. That's the whole problem. And the problem is, they have begged the question throughout this proceeding, saying, we're entitled to this decree because it's less than we're entitled to. Well, how are you entitled to it? Well, we're entitled to it because we already had it. It's completely circular. And, I'm just reading the Lummi Indian case, it's begging the central question. What are they legally and factually entitled to? And in Latin, dat. This is a legal doctrine. Legal nemo dat, often called the nemo dat doctrine. No one gives what he does not have. No one gives, or no one can give, what he does not have. It's a legal doctrine. If somebody doesn't own something, he can't give it to anybody. They don't own this water, or at least not those huge amounts. In English, in America at least, we call it the Brooklyn Bridge problem. If somebody says to you, I want to sell you part of the Brooklyn Bridge, you go, whoa, wait a minute. How is it that you own the Brooklyn Bridge? It's a colloquial way of saying the same thing. Let me give you an analogy to what's going on here. They're coming to court, and they're saying, approve this because it's less than what we already own. Now, don't ask us how we already own this, all right? I mean, they've been dancing around that for years and years and years. But let me give you an analogy. I were to come to court and say, Your Honor, Mr. Oxford and I have negotiated a settlement about the ownership of the Brooklyn Bridge. And we have negotiated long and hard over that, and in good faith. And we had lots of knockdown and drag-outs. And we've agreed that Mr. Oxford owned 57% of the Brooklyn Bridge, and I own 43% of the Brooklyn Bridge. And Your Honor, here's a quiet title decree. Would you please sign here on the dotted line? Well, no, wait a minute. All right, but, Your Honor, this was negotiated in good faith, et cetera, and has all sorts of protections and so on and so forth. And, if you sign this, we're giving up our claims to the George Washington Bridge. Because we could claim the George Washington Bridge. They can claim anything they want, but they've got to prove it. Anyway, so that's it in a nutshell. We'll talk about this more. And I would ask them to find a case that says that, beneficial use has somehow been repealed, et cetera, et cetera. Okay, now.